Today I'm joined by Laura Pickering from More Insolvency, and the clue, as ever, is in the name. We're going to discuss all things insolvency. Laura, thank you for travelling down to see us today. I want to get straight into it and discuss bankruptcy. For a lot of people, that's like the ultimate catastrophe. Sometimes, I even this morning was reading on Facebook about the woes of Beverly Callard, who used to be in Coronation Street. I can't remember. She was married to Jim McDonald, wasn't she? Right. And that she's facing some financial difficulties. She's going back into I'm a Celebrity best of series or something. But we're always reading in the papers about celebrities who have got financial difficulties, and perhaps not Bev Callard, but different people. Sometimes they are faced with a situation where the only option is to go down the bankruptcy route and being declared bankrupt. I guess my first question, what does that mean?
So, yeah, I think there's two different options available with bankruptcy. Either you, as the individual, take matters into your own hands. Yep. You can go online. You can apply for your own bankruptcy. There's a small fee to pay, about £680. And you just go online, fill in the forms. And yeah, the case gets looked at by the government department who handles insolvency, called the official receiver. And they look at your application, check it's all correct, check that you are eligible for bankruptcy. And if you are, then in a couple of days, you'll be bankrupt. So fairly straightforward process.
Okay, so I'm in a situation, if I was in a situation where I had got a lot of debt, a lot of credit card debt, perhaps I'm behind on my mortgage, I just am struggling to even make the minimum payments each month. Maybe I still owe money on my car loan. I've just sort of got debt. It's got completely on top of me. And I've heard of this option of, being declared bankrupt. I guess first question, what does being declared bankrupt mean? What happens to all of that debt when I'm declared bankrupt?
Yeah. So when you're made bankrupt, any debts that you have when the bankruptcy takes effect, subject to a few things such as student loans, child maintenance payments, those still have to be paid. But generally, the remainder of your debts all get grouped into your bankruptcy.
So it's like a government order, so to speak, or a court order that effectively writes all of the debts off.
Correct, yes. So obviously it does come with the downside that your assets have to get dealt with. But yes, your creditors don't get paid. Obviously things like your mortgage, you still have to pay that. They still have security against your property. And if you don't pay that, then they can still repossess your property.
But all the unsecured
debts, yes, they all get grouped into your bankruptcy and effectively get written off. And
vanish forever.
Correct, yeah.
And some, perhaps for a lot of people, the sort of worries that go with that vanish forever at the same time as well.
Yeah, I mean, that's the idea of bankruptcy. It's supposed to be rehabilitative for the person involved.
I mean, in terms of the process of applying for it, for the most part, these days, people will actually, that part of it, they'll do themselves, right? How do they do it?
It's surprising, I think. Some people will. Some people want to take that into their own hands.
Okay. So if they do want to take it into their own hands, what's the process?
Yeah, so you just go on the internet nowadays. So you don't have to go off to court like you used to. You go online. It's all on the government website. Fill in an application online. Pay a fee of £680.
And is the form particularly complicated, or?
No, not really. It just asks your own personal details, what your assets are, what your creditors are, income, expenditure. If you've had a business, maybe some details about that. But generally, it's there for people to be able to do it themselves.
Written in plain English.
Exactly, yeah. They haven't made it overly complicated.
And they can get some help, seeing somebody like yourself or somebody?
Of course, yeah. So there's ourselves or the firms available, things like Citizens Advice Bureau as well, and people online. So yeah, there's plenty of help available.
And you will, if that person comes to see you, one, help them with the form, two, discuss if there are any alternatives to bankruptcy.
Of course. Yeah, because I think obviously downside to going online and doing it is that, is it the right option for you? Are you getting that advice? You know, if you just go online in an evening after you put your kids to bed and declare yourself bankrupt, have you actually thought about whether it's the right option for you? Or is it just something that you've done because you can't see a way out?
If the debts are getting on top of you, and clearly, and we'll come on to it, there are some downsides of bankruptcy, or there's at least some processes that you've got to go through that have got negative consequences. But what if bankruptcy is one of those options to, in effect, deal with the problem? What are the other two would be? Well, I'm going to say there's an IVA option, and sometimes just working it through or doing sort of side deals with your credit.
Yeah, so there's the informal options. You know, you can get a debt management plan, which is just an informal arrangement with your creditors, or there's an IVA, which is a formal binding arrangement with your creditors. Also, if your debts are minimal, if you've got less than £50,000 and you've got really no assets, then you can apply for a debt relief order, and that's free of charge. So there's absolutely no fee for that nowadays.
That's for debts when the total number of their debt is at the lower end.
Yeah.
If I'm being honest, I'm sort of one of those unusual individuals. And whenever I've said this to clients for years, I'm like a pro bankruptcy person. I'm a little bit skeptical about debt management plans because I feel sometimes, they are sold to quite vulnerable people. Yeah. And a lot of the time don't make a lot of sense, insofar as people, you know, in terms of, say, your credit rating or whatever, the chances are once you've entered into one of those plans, it's sunk anyway. And these things sometimes can continue for years and years. So, you never get the finality of the bankruptcy order, which, you know, you declare bankrupt straight away, and within a year, normally it's gone. Are you a sort of debt management skeptic, or do you see them working in certain circumstances?
I think that the government is bringing out more regulation about them, which I think is needed. I've seen a debt management plan where somebody was offering to pay creditors back over 30 years, and that is ridiculous. That's longer than a mortgage would be. And really they were paying back 20, 30 pence in the pound to all of their creditors. That's just not what debt management plans are supposed to be for. Nice,
short, sharp 2 or 3 years to get it sorted and get it dealt with. That's what we want to see.
Exactly, yeah.
What's an IVA, though? Because that's just that you're pro-IVA in certain circumstances, right?
We are, yeah. So IVAs are an alternative to bankruptcy. As I say, it's a formal arrangement. It is a binding contract. So whereas in a debt management plan, you could have a creditor decide that they don't like that agreement anymore and still pursue you. With an IVA, all creditors are encompassed in that. So even if for some reason they weren't aware of the IVA when you agreed it, you know, you've just accidentally forgotten about them when you put it together. Yeah, they are tied into the arrangement, and usually they're no more than 5 years. Again, we do see people where perhaps they shouldn't have had an IVA, particularly if it's people who are only on universal credit or other forms of benefits. And I think, again, there is regulation being tightened about those IVAs and the providers.
IVA stands for?
Individual Voluntary Arrangement. Okay. So it's for a person.
Yeah.
It is not, I've had people say, oh, my husband and me are in an IVA. Yeah, you're in 2 IVAs, individual to you.
Not a joint one, yeah.
No, exactly. There's no such thing as a joint IVA.
But voluntary being a key part of it, insofar as, first of all, you've got to consent and put it forward to your creditors, I assume. And then secondly, it's voluntary a little bit on the part of the creditors because they get to vote in favour or against it, right?
So 75% of those creditors who vote have to agree to the IVA. But often nowadays, people like the credit card companies, the loan companies, they generally tend to agree, provided they can see that there's a benefit to them. So every IVA has to show what the outcome would be as opposed to a bankruptcy and an IVA. And the intention is that the IVA is a better return to creditors.
Better return being in terms of pence paid on the time.
Yeah, a better financial return.
I mean, this is like, far too generalist, but, and I think years ago, somebody would say the typical return on a bankruptcy would be 10% for the creditors. Less than that now, you'd say, right?
I think so. I think a lot of bankruptcies probably don't return anything, and not because they can't. It's just that They don't necessarily have the assets. People still do go bankrupt where a debt relief order might have been a better option for them. But because they've just gone for the wrong option at the end of the day, because they haven't had that advice up front as to what was the best option for them.
But an IVA though, typically for it to be better, they would be being paid 30 pence, 40 pence in the pound?
Again, there's no hard or fast rule. No. Again, I've seen them do 15, 20 pence in the pound.
Been passed.
Yeah. Again, because it could just be that somebody, it's just a working class person. They don't necessarily have a large amount of debt. They could just be, a teacher or a nurse, and they've got into some financial difficulty. They haven't got a massive surplus income, because the IVA means that you pay amount each month into a pot from your surplus income. So it could be that you're only paying £200, £300 or even less into the IVA. So it doesn't necessarily have to be a huge financial contribution. It just has to be better than what a bankruptcy would produce.
I wanted to sort of move back to the bankruptcy. As I say, I generally speaking, I've recommended people go and take insolvency advice, and that advice often is that they should declare themselves bankrupt. And I want to go as far as to say I've never met a single person, and there's been dozens over the years, whereby when I've spoken to them 2, 3, 4, 5 years later, they haven't said to me that's the best thing I ever did. Like the mental health release that comes from that sort of cathartic moment of properly dealing with it, and sort of actually in a form, a sort of a mental health challenge that you actually can sort of slay the dragon with the bankruptcy. And that's kind of how I have sort of often seen it with a lot of other mental health challenges that people have. In my experience, that's a lot. Those demons are sort of far more difficult to slay, for want of a better word. And I just think that if it is the right solution and you've had the proper advice, it genuinely does enable people to sort of move on with the rest of their lives.
I'd agree. I think it's definitely a weight lifted. I think as long as when you are declared bankrupt, you cooperate, you'll have either an official receiver or a trustee in bankruptcy in place. I think the main thing is that you cooperate with those.
Their job is almost like to supervise. I know that supervisors is sort of slightly separate. It's a specific term in insolvency, but their role is to review your forms, to oversee the process.
Yeah.
And what is that process typically then? What are they doing when it comes to, for example, your assets? You might own a house, or you might own, I don't know, some expensive jewelry or whatever. Yeah. How does a trustee in bankruptcy who's supervising an individual's bankruptcy, what is their role?
Yeah, so we'll obviously deal with the debtor, see what assets they do have. And as you say, it could be a property. So if there's a property, we'll get a valuation, find out what the charges outstanding are on it. If there's a mortgage, see what the equity is. It might be solely owned. It could be jointly owned between a husband and wife, or a husband and partner. And again, we will speak to the individual involved and say, right, well, this is what your equity is. How do you want to deal with it? And there are options available. And that comes back to how you deal with it going forward. I think the more you can cooperate, the easier the process is for you. Whereas I think people who don't cooperate, it just start getting difficult again.
Yeah, because for for example, the house, which is, I guess, one of the most common assets, because it's an asset, that is something that the trustee in bankruptcy is obliged to see if they can realise if there is equity in there to pay off, to contribute towards the debt. Lots of the time, though, that is very rarely realised actually by a trustee seeking repossession of the property. I mean, you're there to try and, for the most part, facilitate some sort of deal, whether it be a partner is able to sort of buy out the interest, or a relative, or something along those lines.
Definitely, because, a repossession is always our last option. We will always want to try and come to an arrangement. Also, the cost of a repossession means that the creditors are getting less, and our job is to get the best return for the creditors. So if we can do that by reaching an agreement, then that means that we're saving money in the estate, not having to pay the solicitor's fees. And it could be that the debtor voluntarily agrees to sell the property as well. again, we always present these options early on as well. So give them the time to consider, and you know, if they want to take their own advice, they can do so, or the joint owner may wish to.
There is a further thing that occurs. You am I right in saying, as this changed maybe, you don't have access to a bank account whilst you're bankrupt?
No, you can have a bank account.
Okay.
Generally, so if you have a bank account and you're declared bankrupt, if it's overdrawn, they will close that account.
Okay.
And usually you would only be able to get access to just a general basic current account, no overdrafts, obviously no credit cards. So it would just be a normal bank account. But there are banks who offer bank accounts to bankrupt individuals.
But from a practical perspective, whilst I am in the sort of bankrupt period, what sort of impact is this having on my life?
Yeah, so that bankrupt period usually lasts 12 months initially. If you don't cooperate, it can be extended. But provided it's only the 12 months, then there are restrictions. So you can't be a company director. You can't obtain credit of more than £500 without declaring your bankruptcy status. But I think generally, as I said earlier, it's rehabilitative. The purpose of bankruptcy is it's not meant to be punitive. It's not meant to hang over you for years. It's supposed to afford you the opportunity to move on.
And if you do cooperate and you are released within your 12 years, and then that's the beauty of this, right? Yeah. It's done.
Yeah. I think it can last longer than 12 months, for example, with property. So we have 3 years to deal with a property if it's a matrimonial home. But again, that depends on how you want to deal with it. You know, if you're going to, as a bankrupt, string things out, not cooperate, then again, you're going to make your life harder. It's going to drag on. But if you deal with it quicker, then yes, you can put this behind you.
One of the things that they are typically is ordered or is agreed during the bankruptcy period is an IPO. What's one of those?
So you can get an income payments agreement, an IPA, or an order, which is an IPO. So that's if somebody has surplus income. So we will review what their income is, what their expenditure is. And if they do have surplus income, which, you know, nowadays with cost of living crisis is getting less and less. Yeah. Then yes, you can agree to pay voluntarily 36 months of contributions into your bankruptcy estate. Or if we can see that you've got surplus income and you don't want to agree voluntarily, we can go to court and get an order that you pay.
When I have discussed that with clients, they sort of slightly get hung up on that. And I've always said, well, both the law and in terms of what the trustee in bankruptcy is seeking, it can only ever be a number that you actually can afford. Yeah. It's never going to be a number that you can't afford. Yeah. And that's your sort of, particularly when there aren't any other assets, that's your contribution towards the debts. Yeah. But it's far, far less than what you were paying.
Yeah, I think there's got to always be a consequence. Yeah. You know, bankruptcy, yes, it's rehabilitative, but at the end of the day, there has got to be a consequence to the fact that you couldn't afford to pay your debts back. And if that does mean having to pay a contribution for 3 years, then that's that. But again, at the end of the 3 years, that's it, you move on.
So in terms of the position when we've got somebody who's facing debt and facing that sort of, it's a really difficult time in their life, what would we say? Go and take some proper advice.
Yeah. Definitely. That's the first thing to do. As I say, there's so many advisors out there. And whether it be, yes, there's people available.
We've got citizens advice.
Yeah.
There are lawyers, and so you can find that on the Solicitors Regulatory Authority website. And there are insolvency practitioners.
Yeah.
I'm not keen on pushing people towards debt management companies, but an insolvency practitioner is always going to be licensed and subject to regulation and isn't going to be particularly biased in whichever form of process that you need to do. So it can hopefully help you get to the process that best suits you.
Yeah. And on the government website, there's a list of local insolvency practitioners available. So if you can't find one, or nowadays on the internet, you Google local insolvency practitioner, it will come up with people who aren't local, because obviously that's how people put their own marketing. Yeah. But if you go on the government website, you will find a genuine local list of insolvency firms.
And the government website is, I mean, I know that people can Google, but it's like insolvency.gov.uk, is it?
It's the gov.uk website.
There's just the section of that deals with,
find an insolvency practitioner.
No, and that would be, that's good advice, I'm sure.
Yeah, because again, as you say, they're all regulated. The government don't just put people on there without checking who they are.
No. Wanted to move it on. We at Anson's, give a lot of advice to businesses and business owners. And of course, in the same way that individuals can be declared bankrupt, there is a version of that, or multiple versions of that, for companies.
Yeah.
What are the basic forms that a company insolvency can take?
So you could have a company voluntary arrangement. So similar to an IVA, a company can have an arrangement with its creditors.
Okay, that's slightly less formal, but it's contractual.
Yes, yeah. And again, the company agrees to pay an amount into a pot, and that effectively goes to repay their pre-existing debts. So it draws a line in the sand of their debts. Obviously, going forward, they have to continue to meet their ongoing obligations or ongoing liabilities. But in terms of past debts, it draws that line and again offers a return of 8 pence in the pound to its creditors.
I wanted, though, to move on to the ones that will end in Asian.
So, yes.
What options have we got there?
So we've got administration. And we've got liquidation. So administration would usually be where there's an ongoing business that is viable, that can be sold. Whereas a liquidation would be where perhaps the business has just reached the end of its life. There's not really anything left.
End game.
Yeah.
And we see, I think where people would be quite familiar with administration is we often, I guess it gives a good example, when we see some of the football clubs going into administration. I think Derby County recently were, maybe some of the clubs up in Stoke, perhaps in the 90s, have got different issues in that regard. I know that Port Vale was at one point, but there you've got that asset, which is the football club with its place in the league, and clearly that is something that the administrator is going to be, or the people who run the business are going to be keen to salvage. It's there to be, it's salvageable. But it's got all of this debt.
Yeah. Also retailers as well. That's been a big one recently. Large retailers going into administration. And
Debenhams was one of them.
Oh, exactly. Claire's Accessories has been a recent one this year as well. And I think Body Care, although unfortunately they're now closing their stores. But the purpose of the administration there, we are talking about big companies, is that it allows the administrators to restructure the brand and restructure how that business moves going forward. So, for example, an administrator, if a large company like that would review, okay, these are all the stores we've got, which ones are profitable, which ones aren't making a profit, and use the administration process to close down certain stores.
Yes, because that's one of the things about administration. It stops or the creditors doing for anything else. If you get the votes and the court approves the administration order, it's like a shield, isn't it? It gives you stops the clock for a period of time.
Exactly. Obviously, that's big companies. It does, it works just as well for smaller companies as well. So it might be that you've got a local retailer who has gone into administration and continues to trade. And you think, well, hang on, if you've gone insolvent, how are you still doing that? So very often the role of the administration is for the administrator to try and hopefully find a buyer for the business.
And keep the creditors at bay whilst it does that.
Yeah.
And I think that normally, and what probably holds those things together, like football clubs, like large retailers, there is, whether it be goodwill in the name or the brand or the supporter base of the football club, there is something there that is worth saving, worth trying to find a rescue for. Albeit typically, I think years and years ago, decades ago, and a company would come into and out of administration. That doesn't happen that often now, does it? Is for the most part, aren't the company's assets sold to Newco, Phoenix Co? Yeah,
so often you'll get what's called a pre-pack administration.
I wanted to go on to the pre-pack. Yeah. Pre-packs have got a bad rep in some respects.
They have, and again, the government have tried to tighten the legislation to bring down that bad reputation, but effectively a pre-pack administration is where there's already been a deal agreed. So the day the company enters into administration, effectively a sale's already been agreed. So there's a seamless transition between old owner and new owner.
I think sometimes what the frustration is, if you're owed money, and I've had clients who've gone into administration and then Newco should have a different name, by the way, but Newco is established and, the assets are transferred the next day. people, if you are owed money by that company, it's frustrating to see that happening.
And especially if it's the same people that still own the business.
Oh no, I mean, of course, when it's the same people driving the same cars and whatever, it becomes very frustrating. That said, the administrator's job in those circumstances is to reach a fair deal, right? Yeah,
so again, the purpose of the administration is to get the best result for creditors. So yes, it might be that creditors have lost money, but ultimately, there's still a business for them to continue to trade with moving forward, but also it's supposed to produce a better return for them. So hopefully they are at least getting some of their money back, whereas in a liquidation, they're unlikely to.
Moving on to then a liquidation. Liquidation sounds more brutal, sounds more like death in some respects. And I guess that's because it is, right? We've got a few different forms of liquidation. The one that I instigate the most often is a compulsory liquidation when I file a winding up petition against somebody who owes one of my clients money. But there is another route into liquidation as well as of court order, is there not?
Yeah, so there's a voluntary liquidation. So where the directors of the company accept that the company is struggling, can't afford to pay its debts, then they will seek advice. And as you say, often we'll get referrals from other accountants or lawyers who have a client who they know is struggling and they will refer them on to us. Or we might find them through the internet and they come to us and they say, look, we know we can't afford to pay our debts. So what is the best option for us?
And that one, just to, we love an acronym of that's called a CVL.
CVL, Creditors Voluntary Liquidation, yes.
It looks a lot like the start of an administration in some respects, in terms of you guys look at, advise and try and work out what the debts are, what the assets might be.
Yeah. And sometimes it could be that we do end up selling the business or selling the assets, but because it's such a small amount that they've got left to sell that it didn't warrant an administration. A liquidation is a lower cost process generally.
If your company is struggling financially, it isn't just that it's recommended that you go and take some advice from an insolvency practitioner, or some advice generally, financial advice. That's a duty, isn't it?
It is, yeah. And I think it does protect directors in the future. If you've sought advice and then your company later goes into a form of insolvency, whether it be administration or liquidation, if you've sought advice early, then legally that can help protect you as a director from being accused of wrongdoing.
I'm a massive advocate on this podcast, and my firm is, when it's advising people generally, that companies or businesses and individuals who run businesses do incorporate because of the benefits of limited liability status. In other words, if the company does go bump into any of these processes, that for the most part, you shouldn't have personal liability. But one of the areas where, as a director, you potentially sometimes can have personal liability is if you trade a company whilst it's insolvent. Could you explain what that means?
Yeah, so as you said, directors have duties, and one of them is to act in the best interest of the creditors. So if you've reached a point where you, as a director, can see that the company cannot afford to pay its debts, you should not continue to trade and increase those debts to creditors, because, as you say, that's the point at which a director could be held personally liable if they knew or ought to have known that the company could not afford to continue to pay its debts.
Because if you just plough on regardless, optimistically thinking that next month it's going to be better when it's so clear and obvious that it's not, in those circumstances you could, even though you're a director and even though it's a limited company, you could potentially be incurring personal liability.
Correct. Yeah. And that's what, as I say, seeking early advice is the best thing to do, because one of the defences the director has is if they've sought advice from a professional advisor. It could be that a professional advisor tells them, do you know what, at the moment, just continue for a little bit longer. There may be some hope on the horizon that the professional advisor can see. So if you've sought that advice and you can show that you sought that advice, that's an excellent defence for a director.
Even if that advice is yes, continue, and then it goes wrong, because you've got the advice, you've got your defence.
Yeah, exactly.
Something like trading whilst insolvent is actually one of the things as a liquidator, as an insolvency practitioner, that when you are appointed, that you have to investigate, right? I mean, you do need to sort of mark the homework, for want of a better word, of how the company's been ran, and you are obliged to report that to the government, are you not?
Yeah, so the Department for Business and Trade, we are required to report on the director's conduct. So that might be, as you say, trading whilst insolvent. There's other things that we have to report on, and particularly in the last few years, it's been COVID. Loan.
I was coming on to that. So the C-bills, as they sort of are called, I'm not even trying. And the bounce back. B-bills. Yes. And yeah, you've got no choice on that. You have to, even if it's to report that there were none, you're obliged to do that.
Yeah, we've been left to police the loans that the government handed out like candy at the time, with very little checks.
I mean, have you been the rumour at the time was that all of a sudden Porsche dealerships were selling out of at the extreme? Have you seen some examples of that sort of stuff?
I don't think I've had anyone who's bought a yacht yet.
Okay.
We have had it where the directors have just used it for their own personal benefit, or have put it into a different company. And unfortunately, the bounce back loans and the C-bills loans were very strict about what you could use the loan for. So unlike a normal business loan where the director could choose, what to do with it to, a certain extent, it had to be used for the continuation of the business and for the business that applied for the loan.
So when you see that in effect, the loan has been abused, it wasn't used for the right purpose in accordance with what it was meant to be, potentially you are seeking to recover that and the government, or how does that work?
So it depends. So director's disqualification is considered, and that's something that's done by the government. And there's been a big rise in director's disqualification numbers in the last few years because of misuse of COVID loans, or that they've applied for them incorrectly, because companies could only apply for up to 25% of their turnover. But again, nobody was checking this. So often we find that companies, whilst they might not have misused the loan when they've received it, they've actually misapplied for it because they've over-applied for the amount that they could get.
I mean, in certain circumstances, are they actually personally liable to repay that because of that, or is that indirectly?
The government has the power to pursue a compensation order against the director personally if they've been disqualified as a director, and often that is now as a result of misuse of bounce-back loans.
And you've seen that happen?
Yeah.
And what's the tail on that? I mean, I don't know. I can't remember how long late into the crisis could you still get a COVID loan, right to the end of 2022 or beyond?
No, I don't think it was that late. I think it was only about mid-2021 perhaps. So okay. I think we will start to see these things tail off a little bit over the next few years.
Standard limitation period is 6 years. It doesn't always quite work like that in insolvency.
No. I think the government can take action up to 2 years post liquidation.
One of the other things, or two of the other things that you are looking at as a liquidator in the run up to the insolvency in terms of looking at how a business has been operated, and again, keep saying this, go and take that insolvency advice early, is preferential payments and transactions at an undervalue.
Yeah.
What are they?
So I think just sticking with companies, I think sometimes perhaps when directors can see the writings on the wall, perhaps they start to do things that they probably wouldn't have done previously and maybe start to get a little bit desperate. So for example, transaction under value is where assets have been moved away for either no or less than value consideration. That
great vehicle that's there, he's got his other company and he transfers it for it's worth 20 grand and he transfers it for 5 grand or nothing.
Yeah. I mean, by all means, if assets have been transferred, just make sure you get a valuation. If you can, again, evidence that you've taken a valuation of the asset when you've transferred it and bought it, that's fine. But if you just do it because you can see that the writing's on the wall and you really like to keep that vehicle because you use it every day.
Preferences. Typically, I mean, one of this could be, well, I owe money to the wife and she gets paid. Or my brother-in-law is one of my creditors.
Yeah.
Miraculously, his invoices are paid in full, but the merchant or whatever has been left to, and that's one of the things that you can look into and actually some certain circumstances seek that money back.
We can, yes. So if creditors have been personally preferred, then yes, we can pursue them. And it could be the director themselves as well, because often directors are owed money by the company. And again, often you'll find that their loans have suddenly come down a lot and they've started to repay themselves during that period.
One of the things that I've always found counterintuitive when it comes to preferences is you go and do something that actually on one level makes sense. You've got a debt with the bank and you've gone and made sure before you went under you've paid it off. That might be your only debt that's got a personal guarantee in it though.
Yeah.
And then you've preferred the bank to the other trade creditors that you've got because, they've got the personal guarantee, and even that can be looked at.
That would also be a preference, yes. If you've repaid a creditor because you've personally guaranteed them as a director and you want to make sure they can't pursue you for that personal guarantee, then yes, paying them using company money during that insolvency period is a preference.
I think, though, what that reiterates to me is the importance of getting the advice and getting the advice early, so that even if actually there are things you can do to make a softer landing for the people that you care about that are connected to your business. There are things you can do to minimise your liability to personal guarantees, but it's got to be done probably in a reasonable way and not in an extreme way. And the person, again, best place to give you that advice is somebody like yourself.
Yeah, it's definitely, we see people all the time. And sometimes it might be that we see people and, do you know what, they actually don't need us yet. And coming back to what we were talking about with wrongful trading, just seek advice. Even if the advice is, look, you're okay at the moment, continue, see how things go. That doesn't necessarily mean that you shouldn't take that advice.
And clearly, if, as they increasingly are, the government department is looking at, director's disqualification or anything like that, if they can see the chance of them doing that in circumstances where they can see that you've actively and early been taken proper advice on these issues, the chance of them coming after you in those circumstances are vastly reduced.
Yeah, definitely. I think all about directors' conduct is just their conduct, how they've acted both before and after the company goes into liquidation. Because again, a director has a duty to cooperate with a liquidator. So just continue to answer their questions, because often you can find a way out of things just by cooperating. But it's when you continue to bury your head in the sand that things just get worse.
We seem to be moving into a period in the economy where it's getting difficult.
Yeah, I think particularly over the past 12, 18 months, the cost of living crisis, the increase in the national minimum wage, particularly retail, hospitality industries have really been hit hard with that. Employer
and national insurance contributions.
Yeah.
Tougher for businesses, tougher for individuals. Definitely. Are you noticing an uptick in insolvency? What are the official figures telling us currently?
I think it's definitely been an increase over the past couple of years. I think actually post-COVID, it was a slower uptake on insolvency than everybody was expecting. I think because those COVID loans and the furlough scheme got people through.
Yeah.
But I think now, when it comes to, if you've taken out a COVID loan of £50,000 and suddenly you've got to pay £700-800 a month repayments, that's quite a lot of money. If you're a small business, that could be the equivalent of somebody's wage, or if you were paying minimum wage and you were hospitality, it could be a few people's wage. That's a lot of money to find to repay. So still we are finding people coming to us saying, look, I just can't afford to repay. And it could even be the COVID loan. And they don't necessarily have a lot of other creditors, but the COVID loans are, it was great at the time and people took them, but now the consequences are coming back.
Yeah, and it's natural to take them, but if these things are a problem for you, if that repayment of that just isn't affordable, again, get the advice.
Yeah.
And because often the thing to do is to put the company into an insolvency process. And I think that what I said about bankruptcy earlier in this podcast is correct for corporate insolvencies too. That for the most part, continuing to struggle on can be bad for directors' mental health, and confronting those issues, taking the advice, getting the situation dealt with. There is always light at the end of the tunnel. And I think perhaps maybe more in America than in this country. In America, they wear these corporate insolvencies almost as a badge of honor, or even the individual ones. I went bankrupt 5 times before I made my first million. I think there is probably more of a stigma in this country.
There is. And it is surprising because really, if you look at the number of insolvencies, personal insolvencies in particular, it's on the rise, always is. So it's surprising that there's still that stigma around it. But I think yes, taking that initial step and seeking that advice is always the hardest thing. But like you said earlier, I think it's very rare that we'll have a director that if you speak to them 6 months down the line, you know, we always say to them at the first meeting, this will get easier. And they would always agree that it does. I think having that, you know, the sleepless nights worrying about how your company is going to be able to afford to pay its debts. And, you know, if you've got employees as well, that's a big thing. You know, it's not just yourself then. It's other people that are relying on you making your business work. And it is a difficult step.
I spoke to a director or a former director of a company only last week who went through that process, had to pay some stuff back as part of it, set up a new company. And, you know, actually, and weirdly, perhaps counterintuitively, looks back at it as a positive experience. And his liquidator was Mustafa at the time, your co-director at Moore. You know, and, you know, how's Mustafa getting on? Like, sees that as like a positive. Once he's asking after the insolvency practitioner. So you're not undertakers.
No. I know that nobody wants to come and see us in the first place, and it is a difficult step to take. And I think it's like with everything, admitting that you need help is always a difficult thing to reach that conclusion of. But I think, as I said, when they do come to us, you know, again, it helps draw a line in the sand, helps you move on, and hopefully you can.
And I don't want to genderise this, but especially for sort of middle-aged men, lots of your identity can be put into this business. You know, there's ego attached to it.
Yeah.
Like, it sounds like you're admitting defeat or failure. And I think that the reality of it is, what it is doing is taking a step backwards to move forwards in the long run.
Yeah.
You know,
people put their own name on their own business. You know, the amount of companies that we deal with where their own name is in their company name. So yeah, it does feel like a personal failure. And as we say to everybody, nobody sets out in business wanting to end up in an insolvency process. But like with most professional services, we're here to help. And we're here, okay, we are the unnecessary evil sometimes, but that's what we're here to do that job and to help you move forward and find a way through the problems.
Well, I think that's a good place to end it. Thank you, Laura, for coming on today.
Thank you very much.